Amy Pittman here with Pittman Law Office, and today I want to talk about how you can make sure that your final wishes, whether that's about your personal property or your assets or who you want to be in charge, actually sticks. And that is through estate planning. And I know a lot of people don't want to think about, what happens if they become incapacitated or when they die, but you need to plan, because if you don't plan, then someone else is going to make decisions for you, and it may not be in line with what you want. So for personal property in the state of Florida, you can actually have a separate writing where you can list out, who do you want your, engagement ring to go to, or your car, or your dog. So by listing out those items and who you want it to go to, all you need to do is date and sign it, and that's going to be followed. Now, we need to be able to find it when you die. So make sure that you're organized. Make sure you have a list of where you have your important information, your financial statements, your tax returns, your legal documents, right? So making sure that whoever you are putting in this position to take care of things if you're incapacitated or when you pass knows where to go in your house to find these things, especially like passwords, right? And how you pay your bills. It's really important to make sure that they can find that. The other way to make sure that your wishes are taken care of is through who you're going to name as a beneficiary on an account or on your will or trust. So a lot of people say, well, I'm just going to name the kid that I'm going to put in charge. They'll do what's right. Well, a lot of times that doesn't happen. So if you have two kids and you have a bank account that you want going to both children, you need to name both kids. Not everybody is going to share with their sibling. So if you just name one of them and you just have that kid as the beneficiary, pay on death or transfer on death on an account, legally that bank or the financial institution must provide to that only one that you name. So if you're really wanting it to go to both of them, it's just as easy to name both of them. And the same thing is going to go for your beneficiaries in your will or trust. You could say, well, I'm just going to name, this person to be in charge, and then they'll get it to all of my nieces and nephews. No, that's not how it works. So you need to make sure that you have your wishes in writing in a legal document that must be followed. And not only is it important that you have it in your will or your trust, is make sure that you have the assets that are going to be there. A lot of people don't realize that when they have an account that has a beneficiary designation, so let's say I name that one person, that account's not going to go into your trust or go through your will. So you want to make sure that you understand your estate plan, make sure you understand the importance of beneficiary designations and how that controls, so that your final wishes get taken care of. And the same thing goes for who you want to be in charge. If you don't plan ahead and name someone as your financial power of attorney or your healthcare surrogate, then the state is going to determine who that guardian is going to be. And we don't want that. You want to make sure that you have the right people, the people that you believe is going to do what's in your best interest if you're incapacitated or when you die. So please make sure that you do an estate plan, whether it's through us at Pittman Law Office or some local firm near you. Make sure that you've sat down and really considered who you want to be in charge if you're incapacitated, for your financial decisions and for your health care. And then when you pass away, who do you want in charge to make sure those assets that you've designated to go through your will or your trust, or if you have a beneficiary designation, that's all set to what you want, and don't expect someone else to follow your wishes. Hope that helps.